Hello, everyone, and welcome to Internet Law Review. For today's story, we are covering the appointment of the newest Associate Justice of the United States Supreme Court, Mr. Brett Kavanaugh, who was appointed and sworn in on October the 6th. This has been a bitterly divisive issue, and this is not Internet political review, this is Internet legal review. And that's one of the reasons that I have not covered it so far. But because Mr. Kavanaugh will be rendering many legal decisions going forward, I thought it was important to try to say something about it in terms of how we should or how we might analyze this situation. Fundamentally, the nomination and appointment of a new justice to the Supreme Court is a political, not a legal issue. And like any political issue, the standards to be applied are very unclear if they exist at all. If this were a legal proceeding, a judge would tell us what the standards to apply are. The judge would explain exactly what evidence is and isn't, how we might consider it, and would explain what the burden of proof, burden of production, and standards we are to apply are and how we should think as a jury. We as a jury might then still disagree on whether or not those standards are met. That is functionally the role of the jury, of course. But the standards themselves are things that are told to us, not merely things for us to decide on our own. What makes this particular issue so complicated is that not only do we have to decide if the standards are met, but in a political context, we have to decide what the standards are. There is no judge to tell us what standard we should use. There is no judge to tell us what evidence is or isn't, or how we should or should not consider it, how things should be weighed. There is no one to set a standard for us to apply. One of the very reasons that this has been such a bitter fight is precisely because there is no standard, and every person is looking at this under a standard of their own choosing. One of the reasons we have been so unable to understand each other is that people aren't applying the same standards in the first place. And there isn't even a need necessarily to be consistent in those standards. Political issues are subject to varying issues that go to the heart of each person, and people apply different standards not always consistently with even themselves. So it is completely possible to say that someone is being inconsistent with something else they've said in the past when it comes to this issue because this is political, not legal, and so the standards to be applied are unclear. So when someone asks, should we believe Dr. Ford or should we believe Mr. Kavanaugh? My immediate response as a lawyer is, what exactly do you mean by believe? Because this is an unclear word in this particular context. If we were in a criminal trial, then to believe Dr. Ford would mean that I'd have to find proof beyond a reasonable doubt that Mr. Kavanaugh committed the offenses in question, which is something like a 95% likelihood, as it's usually thought of by most lawyers. However, some people have suggested that this is not a criminal trial. Instead, this is a job interview. And if this is a job interview, then I might flip that on its head. I might have a presumption of guilt standard. And even a 5% certainty might be more than sufficient for me to pass over a candidate and look to the next candidate in line. So, is presumption of guilt the rule, where less than 50% certainty is sufficient? Or is presumption of innocence the rule, where only more than a 50% certainty is sufficient? We don't know. The standards to be applied are unclear. Presumption of guilt or presumption of innocence, 5% or 95%. Should we believe Dr. Ford or should we believe Mr. Kavanaugh? The standards to be applied are completely unclear and subject to each person's discretion. And that's one of the reasons that we have been so bitterly divided about this. Because we don't even know the question we're asking when we say, believe survivors. Do you believe survivors? What exactly does that even mean? The word doesn't have a precise meaning here because the standard of what it means to believe is a standard that's up to each person's subjective judgment. And if a person says, for me to believe requires only 0.5% certainty versus for me to believe requires 99.5% certainty, either of those definitions is equally tenable because this is a political, not legal context where these terms are subject to pure personal whim. I would suggest one thing of caution, however, going forward. To the extent that we wish to be consistent and have clear standards, which I think is a good goal, we might wish to consider however the standards we have today might apply in the future. We should, to the extent possible, divorce ourselves of the immediate issue and look at this in a more objective and reasoned sense. So if we are going to have a standard with respect to Dr. Ford and with respect to Mr. Kavanaugh, we might consider how we would apply that exact same standard to a different candidate, named by a different president, perhaps a candidate from a president that we like. And we might ask the question, if the standard that we're adopting today is a standard we want to apply in the future. I am not suggesting that Dr. Ford's accusation is made up out of whole cloth. I want to be clear on that. But if we do adopt a standard of presumption of guilt, we might consider the possibility that a political operative in the future would make up an accusation out of whole cloth to derail a nominee for political purposes. We might want to consider that that's something that goes forward in the future. On the other hand, if we insist on proof beyond a reasonable doubt in the political context, we might wish to consider the possibility that a nominee in the future from a president we don't like, a nominee we don't like, might have serious allegations against them. And if we're going to insist on proof beyond a reasonable doubt today, then surely we must insist on proof beyond a reasonable doubt tomorrow. And it would be inconsistent for us to derail that nominee on serious allegations that had not been made to that point. In other words, we need to be sure that whatever standards we're arguing for in this context is a standard we're willing to apply for in every context. And we should really think that through. Is it really the case that we're making a standard here because we're ready to universalize that principle? Or are we making a standard here because we like or dislike this particular president? We like or dislike this particular nominee. And as a result, we've adopted a standard that we are not ready to apply when the shoe is eventually on the other foot. This is a political issue. The standards are unclear. But I suggest that we should, as Americans, deeply consider what standards we want to have in a political context. Are we prepared to derail any nominee on mere suspicion? Or are we prepared to derail a nominee only on the highest level of proof? And are we prepared to apply that standard for every nominee from every president? That is truly the political question at heart, a question that has no answer, and one that I think, more than any, has led to such divisiveness as it relates to this issue. Well, that's all it is I have for now. We will return with legal issues where standards are at least clearer in the future. For now, my friends, this has been Internet Law Review. I wish you well. Cheers. Bye.